Indian polity, justice inside judiciary. This editorial is based on the debate over the Collegium system. However, how are SC and HC judges appointed, which has published in the Indian Express on 8 October 2022. It talks about the Collegium system for judicial appointment in India and related issues. For prelims, Collegium system, 99th Constitution Amendment Act, Chief Justice of India CJI SP Gupta vs Union of India 1981, second judge's case. For mains, constitutional provision for appointment of judges, evolution of Collegium system, issues related to the Collegium system towards representative judiciary. The Collegium system is the way by which judges of the Supreme Court and High Court are appointed and transferred. The Collegium system is not rooted in the Constitution or a specific law promulgated by Parliament. It has evolved through judgments of the Supreme Courts. Parliament of India came with the National Judicial Appointment Commission NJAC and 99th Constitution Amendment Act for reforms in judicial appointment, but the Supreme Court held in unconstitutional and void by striking down the NJAC and 99th Constitution Amendment Act. Since then, the Collegium system of appointment and transfer of judges of the higher judiciary has been debated for long and has been blamed for tussles between the judiciary and the executive, as well as the slow pace of judicial appointments. What is the Collegium system? The Supreme Court Collegium is a 5-member body which is headed by the incumbent Chief Justice of India CJI and comprises the 4 other senior most judges of the court at that time. What is the Collegium system? The Supreme Court Collegium is a 5-member body which is headed by the incumbent Chief Justice of India CJI and comprises the 4 other senior most judges of the court at that time. A High Court Collegium is led by the incumbent Chief Justice and 2 other senior most judges of that court. The government can also raise objection and seek clarification regarding the Collegium choices, but if the Collegium reiterates the same names, the government is bound to appoint them as judges. What does the Constitution say on the appointment of judges? Article 124(2) and 217 of the Constitution deal with the appointment of judges of the Supreme Court and High Courts. The appointments are made by the President, who is required to hold constitutionals with such of the judges of the Supreme Court and of the High Courts as he may think is needed. But the Constitution does not lay down any process for making these appointments. How did the Collegium system evolve? First judge's case 1981 in SP Gupta vs Union of India 1981. The Supreme Court by a majority judgment held that the concept of primacy of the Chief Justice of India was not really rooted in the Constitution. The Constitution Bench also held that the term constitutional used in Article 124 and 217 did not mean concurrence. It means although the President will consult these functionaries for appointment, his decision was not bound to be in concurrence with all of them. Second judge's case 1993 in the case Supreme Court Advocates on Record Association vs Union of India 1993, a 9 judges Constitution Bench overturned the decision in SP Gupta. Also, the role of CJI in primal in nature because these being a topic within the judicial family and the executive cannot have an equal say in the matter. Third judge's case 1998. In 1998, then President K.R. Narayanan issued a presidential reference to the Supreme Court under Article 143 of the Constitution advisory jurisdiction over the meaning of the term constitution. The question was whether consultation required consultation with a number of judges informing the CJI opinion or whether the sole opinion of CJI could by itself constitute a consultation. The Supreme Court laid down that the recommendation should be made by the CJI and his four senior most colleagues. Also, they are not accountable to any administrative body that may lead to the wrong choice of the candidate while overlooking the right candidate. Chances of favorism and nepotism. The Collegium system does not provide any specific criteria for testing the candidate for the post of CGI, because of which is leads to wide scope of nepotism and favorism. It gives rise to non-transparency of the judicial system, which is very harmful for regulation of law and order in the country. Against the principle of checks and balance. The principle of check and balance is violated in this system in India. Three organs work partially independently, but they keep check and balance and control on the excessive power of any organ. However, the collegium system gives judicially immense power, which leaves little room for checks. The imposes the risk of misuse. Closed door mechanism. Critics have pointed out that this system does not involve any official secretariat. It is seen as a closed door affair with no public knowledge of how and when a collegium meets and how it takes its decisions. Also, there are no official minutes of collegium proceeding. Unequal representation. The other area of concern in the composition of the higher judiciary, women are fairly unrepresented in the higher judiciary. What should be the way forward? Balance between independence and accountability. The real issue is not who judiciary or executive appoint the judges, but the manner in which they are appointed. For that, whatever may be the composition of the Judicial Appointment Commission JAC, it is important to strike a balance judicial independence and judicial accountability. The executive should have a say in the appointments, but the composition of the JAC should be such that it does not result in compromising judicial independence. Justice inside judiciary care must be taken to ensure that the institutional imperative of the court of dispensing justice is maintained inside the judiciary with equality of opportunity and fixed criteria for selection of judges. Reconsidering the establishment of NJAC's acts may be amended to include safeguards that would make it constitutionally valid as well as recognized to ensure that majority controls remains with the judiciary. Gender diversity and representative judiciary. No woman has been appointed as Chief Justice of India so far. There is a need to maintain and promote gender diversity in higher judiciary with a fixed percentage of its members as women judges. That will lead to evolution of a gender neutralization judicial system of India. Justice B.V. Nagarathna expected to be India's first woman Chief Justice of India in September 2027 is a welcome step in the direction. सो थैंक यू फ्रेंड्स। अगर वीडियो अच्छी लगी हो तो प्लीज़ चैनल को लाइक शेयर एंड सब्सक्राइब करना ना भूलें, और चैनल पे नए हैं दोस्तों तो सब्सक्राइब कर लें। एंड इसी तरह नई नई अच्छी नोटिफिकेशन के साथ एंड नॉलेजेबल एंड एजुकेशनेबल वीडियोस के साथ दोबारा आप लोगों के सामने आता रहूँगा दोस्तों। तो सो प्लीज़ लाइक शेयर एंड सब्सक्राइब माई चैनल। थैंक यू। जय हिंद, जय भारत।